Hello and welcome to the analysis of the Hindu newspaper dated November 23rd, 2022. In this video, we are going to talk about two important newspaper articles. Now, these articles are regarding the Chief Election Commissioner and the India-Australia Pact. So, these are going to be very important, very significant for the civil services examination. Do watch this video till the end. And apart from it, we also have a list of important newspaper articles which you can consider reading from the Hindu newspaper if you have extra time. Alright, so with this, do subscribe to this channel because this channel provides you very important videos for the civil services examination. Now, if this is very clear to you, let's start the first important newspaper article. Now, this particular newspaper article talks about the Supreme Court, which is calling out the center over the short tenure of the chief election commissioners. So, what is this article regarding? So, the Supreme Court on Tuesday said the government pays mere lip service to the independence of the election commissioners, and this is evident from the way the tenures of the chief election commissioners have slid down from over 8 years in the 1950s to just about 100 days after 2004. What Supreme Court is saying is that the independence of the election commissioners is becoming a mockery because the tenure of the chief election commissioner is shortening over the period of time. For example, in the 1950s, that is our first chief election commissioner, when our first chief election commissioner was appointed in 1950, he served the 8-year tenure. It was 8 years, 273 days. Sukumar Sen, our first election commissioner. Now we talk about the Sushil Chandra, who was our latest, who was resigned in, who completed his tenure in 2021. He did it for just 1 year, 31 days. And all the other chief election commissioners who have been in the recent past have served only a few days or a few years, that is 1 year or 2 year max to max. This is the background regarding the chief election commission. So now the Supreme Court was analyzing the series of petitions. It is hearing a series of petitions regarding the functional independence of the election commissioners. Now this particular petition, or these series of petitions, talk about the constitution, right? So it is being heard by the constitution bench. We'll talk about what are constitution bench, but first let's talk about the chief election commissioners. Now, election commissioners are appointed by the President of India on the aid and advice of the Council of Ministers. We have the Chief Election Commissioner and we have the other election commissioners, right? And they are appointed by the President of India on the aid and advice of the Council of Ministers. Now, the aid and advice of the Council of Ministers is very important because whatever the Council of Ministers has to say, the President has to appoint that particular person which is being recommended by the Council of Ministers. So indirectly, the Chief Election Commissioner or the election commissioners are appointed by the Council of Ministers. I'm saying indirectly, right? So any kind of politics can come into play in this particular scenario. Now, if we talk about the tenure of the election commissioners, then the Election Commission, that is Conditions of the Service of Election Commissioners and Transaction of Business Act 1991, prescribes that the term of the chief election commissioners and the election commissioners is 6 years or till the age of 65 years, whichever happens first. All right, it can be either 6 years or until you attain the age of 65 years, whichever is going to come earlier, it is going to be your last day, right? Now, when we talk about the chief election commissioners, then they are appointed under the Article 324 of the Indian Constitution. Now, this particular article deals with the appointment of the election commissioners, called for the enactment of the legislation to oversee such appointments. All right, but this particular thing is not happening at this particular point of time, according to the Article 324. Right. So now, when we talk about the Supreme Court in this particular case, then the Supreme Court has to say some things about the election commissioners. First thing that the Supreme Court says is that the Constitution of India has wasted vast powers on the shoulders of the chief election commissioners and the second election commissioner. Second point they say is that that particular person who is appointed as the election commissioner should be competent, and character is very crucial for them, because the key election commissioners can be bulldozed by the governments, and that is why he must be very competent, he must have a very good character. All right. And the third point that the Supreme Court says is that in the absence of a law to oversee such appointments, the silence of the Indian Constitution is being exploited by all. There is an absence of law regarding the election commissioners, and that is why this particular thing silences the this particular silence of the Indian Constitution is exploited by the subsequent governments. And apart from it, the Supreme Court says that the government assures that the person nominated does not serve the full 6 years by picking someone close to 65. For example, let's assume that a person is appointed as the election commissioner at the age of 64. Now, if you appoint a person at the age of 64, then what is going to happen? He's going to serve only 1 year. That is 1 year. And that is what is happening in the recent past. A person is appointed at the age of 63 or 64, and then he only serves 1 or 2 years. And now this particular phenomenon, according to the Supreme Court, undermines the independence of the Election Commission of India. All right. So now the government has came up with the replies to this particular statements which have been made by the Supreme Court. So the Attorney General of India, who is the advocate of the government of India, says that there is no vacuum in the constitution on the issue. He also says that the separation of powers cannot be challenged because it is the basic feature of the constitution. Basic feature of the constitution as enshrined in the Keshavanand Bharti case, right? Now this particular matter is for Parliament to debate and not the court, says the Attorney General of India. What will happen in the future, we do not know. But whatever the Supreme Court will say will be very supreme and everybody will follow up, right? So now there have been a few suggestions which have been made by the Supreme Court. Now the Supreme Court says that uh, instead of being appointed under the aid and advice of the Council of Ministers, let's set up an appointment committee. Now this appointment committee must include the Chief Justice of India, and it is going to appoint the election commissioners to ensure neutrality. Now if you are not electing, or the appointment is not made by the subsequent governments of the election commission, then what is going to happen? It is going to bring about more neutrality, because someone from the outside will come, an opinion will come from the outside, and it will ensure the neutrality. This is the suggestion which is being made by the Supreme Court, a very wise suggestion. We'll see in the future how this particular situation turns out to be, right? And if we conclude on this particular regard, then we need an election commissioner or chief election commissioner like T.N. Seshan, who brought about reforms in the elections, who brought about the idea of voter ID, right? He was a very strong personality, and we need such as personalities like him to bring about less biasness in the election commission. All right. So this is what we conclude over here, and this is it regarding this particular newspaper article. But we have promised that we will talk about the Constitution Bench. So the Constitution Bench is what? It is a bench of the Supreme Court having 5 or more judges. When you have less than 5 judges, that is when you have 2 judges or the 3 judges, then that particular bench is known as the division bench. All right. Now the Constitution Bench comprises of 5 or more judges. Now this particular phenomenon is not routine phenomenon, right? It happens on an ad hoc basis, on a temporary basis, and sometimes case to case the constitution benches are formed. For example, in this particular case, there is a constitution bench of justices like K.M. Joseph, Ajay Rastogi, Aniruddha Bose, Rishikesh Roy, C.T. Ravi Kumar. All of these 5 people have constituted this particular constitution bench, which is overseeing the neutrality of the chief election commissioner, or the functional, what are we talking about? Functional independence of the election commissioners. All right. So now there are various circumstances under which the constitutional bench can be formed. So the first scenario is that according to the Article 143, President can seek the Supreme Court's opinion. This is the first case in which a constitution bench is formed. Now, this particular opinion, which is given by the Supreme Court to the President, is not binding on the President. He can take the advice, he cannot take the advice. This is the first circumstances under Article 143, which leads to the formation of a constitution bench. And the other one is when we have the conflicting judgments. For example, when division benches, which comprise of 2 or 3 judges, delivers conflicting judgments. All right, two or more 3 judge benches deliver conflicting judgments on the same point of law. The law is the same, but there are conflicting judgments by the different benches. Now, this particular thing requires definite understanding and interpretation by a larger bench, and hence the constitutional bench is formed. Now, the constitution benches are set up on ad hoc basis as and when the above mentioned conditions exist. There are only 2 conditions, right? First one is the when opinion is being sought by the president, and the second one is the when there is a conflicting judgments. All right. So these are the 2 scenarios in which the constitutional bench can be formed. All right. So now this is it regarding this particular newspaper article, but we also know the fact that this particular constitution bench topic is important, and hence in 2021 prelims it was asked. All right, so the question was like that: we adopted parliamentary democracy based on British model, which is very true, but how does our model differ from that model? How our parliamentary democracy differs from the British model of or the Westminster model? All right, so now the first statement is regarding the fact that as regards legislation, the British Parliament is supreme or sovereign, but in India, the power of Parliament to legislate is limited. In Britain, what happens is that whatever the Parliament says it is very supreme, it is going to be implemented in the country. But in India, the power of Parliament to legislate is very limited. It can be questioned in the Supreme Court, right? And that is why this particular statement is very right. And the second statement is that in India, matters related to the constitutionality of amendment of Act of the Parliament are referred to the Constitution bench by the Supreme Court. Now, whenever an act is passed, is it going to go to the Constitution bench? There are very high chances that it will go to the Constitution bench when the petitions are made and they are very valid, or they are proved to be valid by the Supreme Court. All right. So now this particular statement is also right. That is why both 1 and 2, that is C option, is right over here. All right. So this is how the questions can be asked regarding this particular topic. All right. Regarding the Constitution bench, the questions can come. And apart from it, other articles or other topics are also very important. We'll talk about them in some future date. But for now, this is it regarding this particular newspaper article. Let's now talk about the next important newspaper article. Now, this particular newspaper article is not very significant, but can be important because India and Australia have signed a trade pact which is known as Economic Cooperation and Trade Agreement, that is ECTA. All right, so our Commerce and Industry Minister Piyush Goyal says that the trade pact with Australia that was ratified by the Australian Parliament on Tuesday will significantly open opportunities for many businesses sectors, and that is why we have signed this particular pact, right, to bring in more opportunities so that businesses in Australia can invest in India and Indian businesses can invest in Australia. If the Australian businesses are going to invest in India, it is going to do what? It is going to bring about more economic opportunities, more employment opportunities, and that is why that is the fundamental purpose of this Economic Cooperation and Trade Agreement. Read about it. Not very significant. We'll talk about it if it is very significant. but you need to understand this particular newspaper article, and that is why we have simplified this particular newspaper article. So this is it regarding this particular article, and this is it regarding this particular video. So thank you from my side. Do like and share the video and subscribe to this channel. Have a good day. Bye.